Hey guys, this is Roxann Smithers with Smithers and Ume-Nwagbo, and this is a note from my Legalpad. So hey guys, this is part 3 in our 3-part series on business divorces. So in part 1, we talked about when an individual is leaving the business, there's a withdrawal or a buyout. And in part 2, we talked about substituting in a new member for an exiting member of a business. And so then in part 3, we're going to discuss the most complicated and often long drawn out version of the business divorce. And this can involve a situation where the parties have decided that the business will no longer exist. This can either be because the parties genuinely believe that the business has run its course, that the business is not profitable and shouldn't move forward, or in unfortunate situations, the parties cannot operate and cannot agree at such a high level that the only recourse they have are to cease operations and they both walk away from the business. And this can be a situation where neither party is willing to accept a buyout from the other party. And so we've got to everyone takes their ball and goes home. So we're going to talk briefly about some of the key points that you'll have to think about and understand in that situation. But of course, for more detail, we can always discuss down the road. So oftentimes, this type of business divorce may be coupled with either active litigation, arbitration, or mediation, or always have the threat looming of arbitration, mediation, or litigation. And so that factors into how the parties are working together or not working together, and how you try to manage what could be a very volatile situation. As we all know, with any type of divorce, romantic or business otherwise, some can be friendly and they work together, and some can be very acrimonious. So one of the things that you have to think about in terms of a full-scale business divorce with a wind down is making sure that the parties can come to some level of agreement or structure for both the managing of the operations of the business until it winds down, and also managing or negotiating the details of the divorce and the wind down of the business. These are kind of be on two parallel tracks that need to happen at the same time. It's in all parties' interest that the business continues to operate and function and generate revenue and possibly profit, because that's going to be needed to fund this divorce, fund the wind down, and hopefully provide a nice bit of money for each party to take away to put into their next venture or put into the next phase of life. So what I often recommend in these situations is that the parties agree to either a set of resolutions, a memorandum of understanding, or some other agreement in writing that discusses how the wind down process is going to work and how the operations are going to work through the process. That can be agreeing on how to divvy up duties, agreeing on how the parties are going to communicate, agreeing on a timeline for actions to take place, agreeing on vendors that may be used for actions to take place, and agreeing on how the cost for this wind down and the business divorce are going to be taken care of. What costs will be handled as expenses of the business, what costs are the parties responsible for handling individually or personally. And once everybody has agreed to these resolutions or agreed to this memorandum of understanding, it's important that everybody sticks to it, and it can be utilized by either side to make sure that the other is held accountable if there are problems going forward. And as an attorney who's represented parties in such situations, it's a nice tool to have if it turns out that one party or another is less cooperative and less acting in good faith in the other party. Having everyone agree in advance to sort of the rules of engagement is a nice piece of leverage for you as a business owner and possibly for your counsel if you have counsel in that situation. So some of the key things that you'll have to think about in that wind down are general things that you'll have to think about in any wind down, except now part of the reason there's a wind down is that the parties are not getting along. You've got to think about accounting and how you're going to handle both the debts of the business existing at the time and any debts that continue to accrue while in operation. How to determine value and distribute the assets, and those can be physical, those can be financial assets, that can be the goodwill, all the things that are on the business's balance sheet. You'll also have to determine how to manage and handle cash, who has access, what sort of information needs to be provided to both parties as you wind down, as you pay off debts, and as you then set aside any funds that will be left over for distribution between the parties. You'll also have to agree on the capital accounts. That is basically each member, particularly of an LLC or partnership, has a capital account showing the balance of their investment in the business, any loans to the business, any debts owed to them from the business, plus the value of their shares as the business has either grown or not grown over the time that it's been in operations. The status of that capital account may often impact whether an individual actually has to reimburse the business for funds, what portion of any funds that are left after the wind down are actually available for that individual to recoup. There can be a lot of discussion and debate about the capital account balance. So it's important to have a CPA involved that the parties can agree on and trust to go through the financial records and come to a determination with regards to each party's capital accounts and any debts that are owed to the business or owed from the business by the different members. You then have to talk about if you have staff of any type, whether they're employees or they are contractors, a timeline and process for drawing that down. That means understanding the contractor agreements, how much notice that you have to provide, whether you can terminate those agreements simply for cause and what is the basis, or if you have to pay out some certain amount on those contracts. And for employees, it's understanding their rights and your obligations as an employer as you are drawing down your staff and laying, either terminating folks or laying folks off, to understand their access to unemployment, their access to severance if that's part of your benefits in your company's policy. You also have to decide on a structure to draw down your customers. How are you going to provide notice to customers? When are you going to provide notice? How long are you going to stay in operation? And similarly, notice to vendors. If they're, aside from your independent contractors, if there are other service providers or vendors that you have contracts with, whether they're month to month, they're occasional, or if there are other long-term contracts, what are the terms of those agreements? What's the process to extricate the company from those agreements, and how much it is going to cost to do that? Then you'll sort of work your way through the process of the wind down of those activities. That's ceasing the operations, that's paying off any final debts, that's distributing or liquidating assets, that is providing the proper notice to the authorities, the Secretary of State, that you are terminating the business, dissolving the business, closing out accounts, and doing that final accounting so that you can distribute final funds to the parties. If this is an acrimonious situation, or even if it's just a lot to take on for the business, you may end up involving third parties. That can be a wind down manager, that can be a business mediator that helps the parties come to terms, or it can be a situation where all parties have counsel, and the counsels are both looking out for their legal interests and legal rights if there's litigation involved, or if they're anticipating litigation, or just simply advising them on their legal rights in the process to draw the business down. In the most acrimonious situations, the lawyers have have really communicated while the parties stayed separate. Or if the business has enough assets and it's a viable concern, or it has some sort of serious public function and it's in litigation, the court may appoint a receiver who has to basically run the business and manage that dissolution at the expense of the parties. So this type of process can be a long road. The more acrimonious it is, the longer the road can be. The more acrimonious it is, the more expensive it can be if the parties do have to involve counsel, are in litigation, or end up with a court-appointed receiver that they have to make sure is compensated under the court's requirements. But the more the parties can be reasonable and work together, the more the parties can think about conserving expenses, and that every dispute takes away from the pot of money that's going to be available at the end to distribute to the business owners, the easier the process can be, and it can leave everybody ultimately with a clean slate where they can move forward. Often at the end of such an agreement, about such a process, you may end up with a settlement agreement where the parties have decided again how to split liabilities, who's going to own what assets that may remain or goodwill that may remain from the business, whether there are limits on a party's ability to compete with each other going forward, who owns customer lists, and also in some cases releasing or waiving any future claims against each other so that the parties can simply move forward with their lives. But if planned out, a wind down can work. And oftentimes there may be funds left over that the parties can utilize to move forward in their next ventures. So for more information from the attorneys at Smithers and Ume-Nwagbo, you can reach us at stulawgroup.com. You can reach us on Facebook as well as LinkedIn. And this has been a note from my Legalpad.